All right, welcome back to the FITSNews studio for another edition of your Weekend Review. It was all judicial reform all the time this week as a huge case thrust this issue to the forefront of the debate here in the Palmetto State. We're going to walk you through the case of Gerard Price, who was released from prison with 15 years left on his sentence. This convicted killer's release has sparked outrage across South Carolina. We're going to walk you through all the details of that case. Dylan Nolan and Jen Wood also are going to bring you the story of Evan Hawthorne, where we are going to see exactly how powerful lawyer legislators manipulate the system to get accused killers back on the streets. Then we're going to go up to Greenville County, South Carolina, where we've got a truly tragic story about the consequences of those violent criminals being turned back onto your streets. All that and more heading your way on the Week in Review. So obviously, if you follow this news outlet for any period of time, you know we've been talking for years about judicial reform, about fixing the broken, corrupt, inherently unfair justice system here in South Carolina. In fact, it's not a justice system. We call it the injustice system because the outcomes that it perpetually churns out have nothing to do with justice. They have everything to do with who you know, who got appointed by whom, who's connected to who. That's how justice works in South Carolina. And so we've been exposing that for years. For years. We've been trying to get state lawmakers, who are the ones who are responsible for this, are the ones who appoint the judges. Again, one of only 2 states in the entire country where this is the case. We've been trying for years to get them to fix this system, to surrender that power, first of all, to strengthen our bond requirements, to strengthen our sentencing requirements, to start putting victims first. And they've done some things. They've, in fact, put constitutional protections for victims. They passed those. We're going to get to that in a minute. But those efforts have largely gone, unnoticed, unsuccessful. Most of the time we just get attacked by the trial lawyer lobby. We're called headline whores. They say that we over-dramatize these incidents, these stories. But every once in a while, a case comes along where everybody gets it. Everybody gets it. They realize, wait a minute, these reform calls that these people have been making, these systemic issues, they're real. There's something to this. And that happened this week. It started on Monday of this week. We filed a report on Monday of this week about an inmate in the South Carolina correctional system by the name of Gerard J. Price. This is a guy who has been in prison for the last 19 years. He was convicted back in 2003 following a murder that took place the previous year, December 7, 2002. Gerard Price is a gangbanger, people. In fact, he's a gang leader. He's what's called a set king in a group called the Gangsta Killa Bloods, which apparently is a very badass version of the Bloods gang. So he kills former University of North Carolina football player Carl Smalls back in, again, December 2002. He's convicted. Took the jury 30 minutes to convict him, by the way. That's even quicker than the Murdoch jury. 30 minutes to convict him. His conviction was later upheld by the state Supreme Court in a ruling that actually impacts whether or not gang affiliation is admissible in court. Imagine that. You have to actually debate whether or not gang affiliation is an admissible item in court. And Price, by the way, the apple apparently has not fallen far from the tree because his son is currently incarcerated in connection with a gang shooting that took place a year ago, back in April 2022, at Columbiana Mall, a very high-profile shooting in which multiple people were wounded. Anyway, Gerard Price was set free by retiring Judge Casey Manning a month ago, mid-March of 2023. And he was set free via a sealed order, people. Something that was never made public. And it was only this month, when this news outlet was tipped off, that the public found out that this killer, this, again, convicted killer, had been set free. Now, here's the problem with, well, there are a bunch of problems with it, but let's start with the first problem. Price's release was illegal because in South Carolina, if you're convicted of murder and if you're sentenced to prison for murder, you have to serve, if it's a sentence, again, 30 years or more, you have to serve every day of the sentence. And former Circuit Court Judge Reggie Lloyd sentenced Gerard Price to 35 years, day for day, which means every day. No early release, no probation, no, every day. That is in state law. That is a state statute. But Judge Casey Manning, in his last week in office, let Gerard Price go. Now, if you have not heard of Casey Manning before, our regular readers know this name because when we were covering some of the Murdoch judicial corruption, particularly Judge Carmen Mullen, who's been enabling corrupt politicians in South Carolina for a long time. When Carmen Mullen got in trouble with South Carolina's Supreme Court, with their Office of their Judicial Conduct, their Disciplinary Counsel, it was Casey Manning that bailed her out. He was the one that got her out of trouble. So this is a guy who has been not only enabling violent criminals and helping out violent criminals, but he's been helping out the corrupt judges who are the problem in our system here in South Carolina. He's just a bad dude. A bad dude. But of course, when he announced his retirement last year, everybody feted this guy. Henry McMaster gave him the Order of the Palmetto, the state's highest civilian honor. Everybody kissed this guy's ass. You know. Not us. Not us. But Casey Manning lets this killer out of jail, 19 years into his sentence. He's got more than 15 years remaining. He wasn't supposed to be released until 2038 via, again, a sealed order. No one knew what was in this order. Well, we now know. According to the order, Gerard Price assisted corrections officials in apprehending an escaped convict by the name of Jimmy Causey. So Jimmy Causey is very famous in South Carolina. He's a guy who broke into the home of a very prominent attorney in Columbia, South Carolina, a guy named Jack Sorley. Jack's actually been in this studio, by the way. Very famous lawyer here in South Carolina. Broke into his home, held Attorney Sorley and his family at gunpoint for hours. So he's sentenced to life in prison. He's actually escaped twice. But it was on the second escape where Gerard Price is alleged to have informed corrections officials that Causey had escaped. Now, Causey had cut his way out of jail through some wire cutters that were dropped into the prison, Lieber Correctional Institution in Ridgeville, South Carolina, dropped in the prison through a drone. Prison cell phones, contraband cell phones, were used to help facilitate his escape. But the theory that we've heard advanced is that Price actually assisted in that process because he wanted to then, on the back end, provide this alleged assistance. Now, there is a statute, South Carolina law, which allows a judge to reduce a sentence in the event a prisoner provides material, substantial assistance to the state. Now, that statute, though, has specific language. It talks about specifically helping save the lives of prison guards or save the lives of other correctional personnel. So if there's a riot, something like that's happening, a hostage situation behind bars, and you help diffuse that situation or you take action that saves the lives of correctional officials, you can get a reduction in your sentence. But there's nothing in there about an escapee, nothing about providing info about an escapee. There's also nothing in that statute that indicates it applies to somebody with a mandatory minimum. So this is one of those situations where you've got a judge basically taking one statute, trying to apply it over another one. But let's get past that for a minute. I talked earlier about the Constitution here and the constitutional protections. It's not a law, people. It is part of the South Carolina Constitution that if a killer is set free, or if any criminal is set free, any violent criminal is set free, two things have to happen involving the victims. Number one, they have to be told about it, okay? They have to know it's going to happen. But number two, they have to be given the right to speak to the judge in public and say yay or nay, say this is why we think this person should be allowed out or not. And again, bear in mind, this is a guy who, he's on a mandatory minimum sentence. He shouldn't be, this guy could have cured the lame, raised the dead, fed the 5,000 behind bars. He could be Jesus Christ behind bars. He's still on a mandatory minimum sentence, people. So I don't care what kind of Lazarus stuff he's doing back there. He should not be let out early for any reason. But assuming for a moment there was a case to be made, he could be. Victims have to know about it. Victims have to be given an opportunity to speak. And that's not a law, people. Again, that is in the state constitution. And guess what? That did not happen. That did not happen. And not only that, so not only is it illegal that this guy got released, it's unconstitutional that this guy got released. But beyond that, it completely violated every tenet of our state's judicial system because it was never even moved by the prosecutor. The judge just issued this order. The judge had nothing to base that order on other than the defense lawyer, who, by the way, we're going to hear about him in just a minute. By the way, the defense lawyer in this case, powerful lawyer, legislator Todd Rutherford. One of the handful of state lawmakers who sits on the commission that literally appoints the judges, screens the judges through. Nobody in South Carolina has more influence over picking judges than that panel. And Todd Rutherford, the lawyer for Gerard Price, is one of those guys. It's unbelievable. But again, this is South Carolina. We've been writing about this for years, but it took this situation, it took something so egregious, something so extra-legal, unconstitutional, and again, in complete violation of the rules of the court. The solicitor in this case did not even make a motion for the release of this criminal. The judge just let him out. Just let him out. So after our story broke, all hell broke loose, people. It got picked up by the state newspaper, got picked up by the Post and Courier down in Charleston. All the TV stations picked it up. The Attorney General of South Carolina picked it up and ran with it, demanded a hearing on a bench warrant, demanded a bench warrant for the arrest of Gerard Price, as he should have. Dangerous guy, people. Gang leader. According to our correctional sources, this guy was running the Bloods in the State Department of Corrections, the top blood leader in the State Department of Corrections. And by the way, I want to point this out. This is also very important when we talk about the kind of people that are getting turned back on your streets, your neighborhoods. This guy wasn't released from a South Carolina prison. And I want to explain that. He was in South Carolina custody. He's under the custody of the South Carolina Department of Corrections. But he wasn't released from a South Carolina prison. He was released from a prison in New Mexico. And he was being held in that prison in New Mexico for a very specific reason. He was being held in the prison in New Mexico because he had threatened to kill not one, but two correctional wardens, according to our sources. He called out hits on two correctional wardens. And this is the guy that, absent an order from absent a motion from a prosecutor, in violation of a state statute and in violation of the state constitution's victims' rights, Bill of Victims' Rights, in violation of all three of those things, this is the guy that Judge Casey Manning unilaterally set free. Unbelievable. Now, the latest in this case, we are told that the bench warrant will be issued. But this goes deeper than that. Folks, they don't need to just get this guy back in jail. That's the first and most obvious thing. This guy needs to be back in prison to serve the rest of his sentence, okay? And quite frankly, there need to be additional charges brought against him for these threatening the lives of these public officials. So he needs to be back in jail. He needs to face the music for what he's done behind bars. But more importantly, there has to be a criminal investigation into how he was let back out on the streets in the first place. And that means that this judge, again, who everybody kissing his ass a couple months ago when he announced his retirement, talking about what a great guy he was, again, given the highest civilian honor South Carolina has. He must be held accountable. He must be held accountable. And I know we got a lot of in the aftermath of us breaking the story and it blowing up everywhere, we got a lot of people pointing fingers at each other saying, oh, well, it was the solicitor saying it's the judge's fault. And the lawyers are saying it's the solicitor's fault. Don't know who the judge is blaming yet, but somebody has to be held accountable for this, people, because when you break the law, violate the Constitution, and violate the rules of the court, there have to be consequences. But the biggest thing here, beyond getting this guy back in jail and beyond holding the people who let him out accountable, the biggest thing here is that, once again, we are back to the fundamental question of how do we fix this system that allows this kind of crap to happen? Because it isn't just this case. Jen Wood, our director of research, and Dylan Nolan, our director of special projects, they're going to talk to you in just a minute about another case involving this same lawyer, Todd Rutherford, the guy that got this gangland killer released. But it isn't just this case. This happens all the time. In fact, let's go right now. I want to go to Dylan and Jen while they tell you about the story of Evan Hawthorne and how Todd Rutherford got another killer, accused killer anyway, back on the streets.
House Minority Leader Todd Rutherford was involved in this big early jail release, but that's not the only story we have about Representative Rutherford for you this week. We also have him being brought in for a bond modification of an accused murderer, and it just so happens that the person that he was representing got off. Now, Jennifer Wood, who I am on this panel with, did some research into this. Specifically, she requested FOIA call logs from the jail of Evan Hawthorne, who is the former police officer who Rutherford was able to secure a bond for. Jennifer, do you want to tell us why Hawthorne was facing legal trouble? Maybe we can listen to some of these calls and then explain why this is significant.
Yep. So Evan Hawthorne, 29-year-old, he's a former Chester County Sheriff's deputy, and he is accused of the murder of former Rock Hill Police Lieutenant Larry Vaughn in July of 2021. So Larry was a 30-year-old veteran of the force. The two of them were out drinking together at a bar. They got kicked out of the bar, and allegedly Hawthorne followed Vaughn to his apartment, and then an hour or so later, Hawthorne was seen leaving the apartment complex, and his clothing, his hands, and his face were covered in blood. So he was arrested and charged with his murder. His first bond hearing, he did not get granted bond. So he was up for a bond modification hearing in the fall. And that's what we were FOIAing for, is kind of what was going on leading up to this bond modification hearing. And
so do you want to cut to these now so that people can understand? Because these calls are between Evan and his mother as they're trying to plan this bond modification hearing. So if you're not aware, in South Carolina, if you're arrested for a crime, they will initially set a bond, and then after a statutorily designated amount of time, you are able to have another bond hearing. And their initial attorney, who we'll hear about, who we've talked about, and who we've interviewed right behind me, Jack Swirling, says, I don't think I'm going to be able to get you bond. And that was kind of what people expected. However, they reached out to Representative Rutherford, and he had a different opinion on the case. Let's hear about it in the clips.
Well, I talked to Todd this morning.
Oh, did you?
Yeah, he called me back. He said that, that he's watching it closely to see what the lineup is for the judges and stuff.
Yeah, I was about to tell you, don't rush him because, you want the right judge.
Yeah, I told him, I think he's up on it, and we're, he said to tell you to be patient. He's working on it, and yeah, he said that, I think that judge is usually a good one, but he said he must be under the spell of something now, and because they allowed the court, they allow media in the courtroom now for certain cases, and he feels like that's what happened with that one, that he didn't want to look bad to the media, I guess.
Yeah.
But he's waiting on something for you, he said.
Okay. Well, don't rush them.
No, I'm not.
Because, you can't control the judges who come here, so it might be a while before we get a good one.
I know, and I'm thankful that he's looking out for you.
Yeah.
At least he's got connections, so I'm hoping and praying
Yeah.
it's the right one,
As you heard in the clip, it is about the connections. That's why Representative Rutherford was brought on here, and that's why this is not okay. I was looking in the YouTube comments after we initially uploaded these calls, and there were a couple people saying, don't you want a defense attorney to vigorously advocate for those they're defending? And obviously that's how the American system of justice works. Don't think for a second at FITSNews that we're pro-cop or that we're trying to get up the prosecutors' backsides. We just don't want the people who are representing accused criminals in front of judges to be the same people who are hiring the judges. That's the problem in this particular instance. You heard Vonda, Hawthorne's mother, talking about the connections. And the connections in this case are connections within the legislative panel that picks the judges. Those are very important connections to have. And that's why we believe that Hawthorne was granted bond, because Rutherford was able to get him in front of the right judge, and a judge who was willing to let him go despite these serious allegations which he's facing.
Right. Yep. So he is currently out on bond. And like you said, everybody is entitled to bond. Everybody's entitled to fair representation. It's
And
just
everybody is innocent until
Right.
proven otherwise in a court of law. If you listen to
Exactly.
Hawthorne, he contends that this was a self-defense situation, and he should have his day in court to make that argument. But what should not happen is he should not be able to hire a legislator to preemptively get him out on the streets before a true, equitable, and fair procedure can decide whether or not he should be back in with the general population.
Yeah, exactly. It's all about them leveraging that position.
Well, I think that your work on the FOIA certainly gives the members of the public a view into the minds of people who hire these lawyer legislators that we haven't yet gotten to see. So thank you so much for doing that. I know Will wants to close the episode out with yet another example, so let's kick it back to him and let him do that.
I want to thank Dylan and Jen for that report, and especially want to thank Jen Wood for her amazing work this week on Freedom of Information Act FOIA requests. She's getting tons of good information from government agencies, bringing it directly to you so that you can see for yourself some of the details of these investigations that we're reporting on here at FITSNews. But these weren't the only cases this week that exposed this ongoing scourge of judicial leniency here in South Carolina. There's another big case that we reported on in the South Carolina upstate, and I'm talking about the missing persons case of Jordan Cheyenne Neibling. Now, Jordan Neibling has been missing ever since October of 2020. This is when she was last seen with her then boyfriend, a guy by the name of Tyler Wilkins. Now, as we dug into this case, we quickly saw that this wasn't just a missing person story. It was yet another story of judges in South Carolina letting violent criminals go with literally no thought to the consequences of what might happen when they did that. And this case is particularly egregious because Tyler Wilkins, back in October of 2021, he was hit with a drug charge and a theft charge. Again, I understand you get bond on those. Those are not necessarily violent crimes, but he's given bond for those charges in October of 2021. But just 2 months later, actually less than 6 weeks later, comes back before the court facing a litany of new charges. And I want to read a couple of these because they're serious. Attempted murder, domestic violence of a high and aggravated nature, threatening a public official, pointing and presenting a firearm, possessing a weapon during the commission of a violent crime. All these charges. And he was let out on bond again by the exact same judge, Judge G.D. Morgan, Circuit Court Judge G.D. Morgan, up in Greenville County. I know what I'd say, GD, this guy. But anyway, this guy lets him go, despite the fact he just had him in his court on these previous charges. Lets him go on a $30,000 bond, which, again, you don't have to pay all that, people. You just have to pay a percentage of it. And you can finance that percentage, too. It's a great deal. So he lets this guy out. Less than a year later, Tyler Wilkins brutally murders the mother of his newborn child, Clarissa Winchester is this poor woman's name. This is one of the most horrific crime scenes, we're told by our law enforcement sources up in Greenville County. One of the most horrific crime scenes they have ever seen. Ms. Winchester died of blunt force trauma to the head due to repeated blows from Tyler Wilkins. And the baby died in that house from neglect as this murder was taking place. Guy shouldn't have been out, people. Shouldn't have been out. And maybe if he hadn't been out, that mother and baby would still be alive today. Enough's enough. We've said it for so long. But the good news about this week, people, is that for the first time in a long time, as I said at the intro, people are starting to get it. They're starting to realize just how broken this system is. So, here's the big question. What do we do about it? Well, I want to tell you one thing that a group's doing about it. A year ago, when we were one of the only outlets in the state covering these issues, when we were particularly covering the Bowen Turner saga of a guy accused of raping 3 different teenagers over a period of less than a year and a half, the outrage over that case sparked a new victims' rights movement here in South Carolina. We covered that rally a year ago. Well, there's another rally coming up May 9 in Columbia, South Carolina at the State House. We're going to be doing a big article on it on FITSNews so you can get all the details. But we were at that rally a year ago, and it was amazing to see this new victims movement coming together. But guess what? Now the lights are on. Now it's time to do something about it. Now we have finally got some real momentum on behalf of these victims. But now we need to talk about the bigger question. What's the end game? What do we want? What do we need to get as a result of all of this just horrific loss of life and tragedy and pain that these families and victims are dealing with? What do we need to get? Well, we saw some motion on that this week as well. Some bipartisan work in the South Carolina House of Representatives as 2 freshman lawmakers, one a rural Republican, old social conservative, one an urban, more liberal Democrat. They don't share a lot of similarity in their thinking and their views on government, but they came together this week for a press conference at the State House where they unveiled some of their reforms. And I'm talking about Heather Bauer and I'm talking about Joe White, another guy who's been in this studio. And we hope to get Representative Bauer in here to talk about her bills as well. Now again, are these reforms the sort of big ticket judicial fixes that I've proposed? Not necessarily. But it is a start. It is a way to begin wresting control of this corrupt judiciary away from the lawyer legislators whose influence is clearly eroding public safety, intruding on the liberties and the lives of these victims, but most importantly, just undermining fundamental fairness and faith in our system. And that's got to be fixed. That's got to be fixed. Now, I've proposed a hybrid model this week, wrote an extensive column on the best way that South Carolina could begin screening, selecting, and appointing judges. And it would work very simply. You'd have a commission that reports directly to the governor, consisting of victims' rights advocates, of law enforcement, of prosecutors, of family attorneys. And yes, put a defense attorney on there. Probably not Todd Rutherford, but we'll put a defense attorney on there. But that panel gives the governor recommendations. The governor then makes appointments which are approved by advice and consent of the legislature, although there's a key caveat, people. That advice and consent vote of the legislature, no lawyers in the General Assembly would be allowed to cast a ballot. Will be solely non-attorneys in the legislature voting on those nominees. But here's the best part. You've got an executive function. You've got a legislative function. The best part is that you, the public, every 4 years would have an opportunity to decide whether or not that judge stays in office. And I've heard a lot of people criticizing judicial election about one candidate versus the other. And I agree. I don't necessarily know if we want, I don't have a problem with it, but a lot of people seem to think it would be bad to have political races with judges. But at the very least, let those judges be subject to an up or down vote every 4 years. And more importantly, let's let them be subject to recall elections, which means that if enough people in that district, in that circuit, get pissed off, they can submit a petition to have a recall election. And once again, it's the same situation. It's an up or down vote. Up or down vote. That is accountability, people. And if they lose that vote, guess what? They're out, and the governor appoints, and that whole process starts again. But I will tell you this, to all the people who have been critical of those reform proposals, look at the current system. Look at this ongoing failure. Look at the blood that accumulates and is on the hands of these lawyer legislators. Because, folks, that's who it's ultimately fallen on. That's who's ultimately responsible. And this week, we've seen egregious miscarriages. We've seen violent acts. We've seen some of the most brazen, in the recordings you heard earlier from that jail up in York, some of those brazen calculation. It is time for that to stop. It is time for fundamental fairness to be put into this broken system. And as long as FITSNews is here, you can count on this news outlet to continue exposing those who are abusing this system and fighting for the reform we need to make it start working once and for all for the people of this state. All right, that's a wrap for this week's edition of the Week in Review. I want to thank everybody for tuning in on a big week as it related to the issue of justice reform in South Carolina. And that reminds me, if you want to support what we're doing, please check out FITSNews.com. And if you really want to help us out, subscribe and help support the work that we're doing to hold those in South Carolina accountable for their actions.